I asked the question of my law clerks and a group of law students who are serving as externs, should the law be colorblind? And I was quite surprised by some of the answers, because there was a general hesitancy on the part of everyone sitting around the table to answer at first. And then as they started to answer, I started to get a lot of equivocation, because there was some feeling that, well, that's a nice ideal, but we aren't quite ready for it yet. That indeed we need to be cognizant of color because we're still struggling with it. And I thought that was a wonderful answer. I turned to the two minority members of the assembly, and they said, absolutely not. The color needs to be a consideration. That indeed, I bring something to the table because of my ethnicity, because of my background, that I want recognized. And so we aren't quite sure. I think that Eric Holder, our Attorney General, says we're too chicken to really talk about race and gender as a nation, and we still are. And so it is something that, as a court, we deal with all the time as we sit there as judges. And we take on a special responsibility. Our court, as I'm sure others, have a committee to deal with professional responsibility, and particularly where people feel that they've been discriminated against in any way during the course of court proceedings on the basis of race or ethnicity or gender. And I'm not sure it's well used, because many people let it pass. We're too polite to say that's discriminatory in our society, and so as a court, we often don't have an opportunity to deal with it.